Welcome to our LinkedIn Live. My name is Lee Morin, and I am the principal attorney and founding member of Morin Legal, your small business and entertainment law practice located on the East Side Beltline Trail in the Old Fourth Ward and Inman Park neighborhoods of Atlanta, Georgia. Today, we are talking about employee-employer agreements. Last time we were here, we spoke on independent contractor agreements and some proposed changes to classifying independent contractors. But today, we're going to talk about the employee-employer relationship and also get into some examples of employee agreements. So you'll want to stick around for that. So to begin, the employer-employee relationships where we intersect with that are governed by a few key statutes, which we're going to mention right now. The first, of course, comes to mind frequently is the copyright statute, essentially because of the definition they use for work made for hire. And you might be familiar with this term if you've worked in any creative capacity, but it essentially governs the ownership of the results and the proceeds of your work product, which are by default in favor of the employer, so long as there is an employer-employee relationship between the parties. So if you are an employee for your employer, you might have been presented with something like an indenture disclosure agreement or some other type of ownership agreement that governs the ownership of the work product that you provide for your employer. So that falls generally under the Copyright Code, which is a federal statute. Also, some really foundational legislation that governs the employer-employee relationships are the Fair Labor Standards Act, which distinguishes, of course, between the exempt and non-exempt workers. The importance of that distinction, of course, being that the workers non-exempt benefit from provisions under that act, including earning a minimum wage with overtime pay and certain benefits. The minimum wage by state currently, if you are interested in that data, seems to lean, politically speaking, in favor of the worker in more blue-leaning states, whereas the minimum wage tends to be on the lower end of the spectrum, closer to the federal minimum in more conservative-leaning states. Of course, we discussed already that the revising of the classification of independent contractor is currently under debate. So certainly tune into our last LinkedIn Live if you missed that discussion. Another statute that I like to often remind people about that is a little less common is the National Labor Relations Act, which of course created the National Labor Relations Board, which helps facilitate conversations amongst workers, whether to elect to organize and join a union. Certainly, there are plenty of unions currently in the United States that you might not be aware of that might be relevant to your job. So it's always helpful to look into that. An example of this right to organize in action lately would be the Starbucks employees that you might have been reading about organizing and voting to organize in various states and localities. And so generally speaking, that's where I see the employer-employee relationship intersecting in our line of work, which is helping employers provide current and meaningful employer agreements and policies to protect their businesses. So let's get into the next part of our talk on the Federal Trade Commission. We talked earlier that we would be discussing this proposed rule banning non-competes in employer agreements. And certainly the Federal Trade Commission is the agency which has proposed this rule and accordingly has solicited comments from the public, which just by accident happened to be closing today, April 19th. And so today is the close of the extended period for providing any comments on the proposed rule to ban non-competes. So proponents of the rule believe there is some dubious authority by the FTC over certain entities, in particular over nonprofit corporations, since the FTC allegedly only has jurisdiction over for-profit companies. So certainly the proposed rule will be challenged by people who challenge that authority. But generally speaking, people who have been studying this rule legislatively and in the regulations that have issued have said this is part of a broader trend that began around 2014 and has really just risen to a fever pitch of late, culminating in, like I was saying earlier, the closure of the comment period today. So what happens after today? Well, the FTC is either going to finalize or revise their proposed rule. They may issue a rule in which there will be a period for compliance, during which I'm sure challenges will be issued. But is it really the place of the executive to be doing this type of work? Is this not the purview of the legislative? Well, you might be surprised to find out that right now in front of Congress are two laws that essentially summarize the aspects of the proposed FTC rule, and those are the Workforce Mobility Act, which also provides for certain exclusions under the rule, and the Freedom to Compete Act, which eliminates non-competes for non-exempt workers. So more skills-based, less knowledge-based workers. Certainly those two bits of legislation are making their way through Congress. So anybody who's interested wants to probably follow those. And last but not least, what to do if a rule is actually proposed and passed. Well, there will be a compliance period. I'd say that's a good time to reach out to a small business lawyer or a law firm and request a review of your employer-employee agreements. So what are examples of employee agreements that we can offer you? Well, earlier, we talked about the invention disclosure agreement, or otherwise an ownership agreement on work product, on the results and proceeds of workers. Confidentiality agreements also are examples of employee agreements, and they can be particularly detailed. You would be amazed. They are distinguished from non-disclosure agreements, which are more like an agreement in contemplation of the relationship. Whereas in contrast, the confidentiality agreement is signed usually at the moment the relationship is engaged, or you are hired, you are agreeing to hold in confidence all of this typically trade secrets and other non-public data that you'll have access to by virtue of being an employee for your employer. These are key employee agreements, and typically will be distinct agreements even into themselves. Otherwise, you might have an offer letter. An offer letter typically will summarize just the key terms, could be your compensation, your pay, who you report to, where you're going to report, when you will report on your first day. So details like this. And last but not least, I think is really important for employees to remember are to review all of your employer policies. This is extremely important now that definitions are being updated with respect to what constitutes discrimination in your state. I think it's really, really important to, as an employer, to make sure that your policies are relevant and are compliant with the latest rules and regulations. So certainly, if you're an employer, I'd say dusting off your agreements and having them reviewed by a qualified attorney in small business law and employment law is it's not too soon to start that process. If you are an employee, certainly being aware that the rule is being proposed is good to keep in mind. And of course, understanding what the compliance period is, so that if indeed you are presented with a non-compete agreement, you have some knowledge proceeding into that relationship. So what is next? Certainly sign up for our blog. Don't miss all the details and examples of employee agreements that we will post as part of our more detailed blog and analysis on independent contractor agreements and employee agreements. Go to our website, scroll down the homepage, and you can sign up for our newsletter and then receive the blog on this month's topic. So thank you so much for joining our LinkedIn Live. My name is Lee Morin. It's been my pleasure. We are here to serve the small business community in your employer and employee agreement needs. Certainly, we welcome you to call our reception for a courtesy discovery call to find out if we might be of service to you and your business. Thank you so much again, and have a wonderful Wednesday.